been talking mostly about cases where you wrote the opinion, but to get into some other cases where you either wrote dissents or concurring opinions. Let's start with DeVesa versus Dorsey from
Right.
1993. What can you tell me about that case?
That involved the reappointment of Judge Espinosa, and if my recollection is correct, I originally administered the oath of office to her when she first became a judge. For some reason, Senator Dorsey objected to her reappointment and exercised senatorial courtesy, which meant that the Senate never considered her renomination. The case initially was filed, I believe, in the Chancery Division in Mercer. Judge Karchman ruled that this was a political issue and therefore non-justiciable, so the courts couldn't decide it. It then came up to our court, and Robert Walentz had spoken on behalf of Judge Espinosa's reappointment, and felt he had to recuse himself. So the court, it was a 6-person court, and the case attracted wide attention. And after we heard the arguments and we conferenced, the court was divided. 3 of us felt that Judge Karchman had it right, that it was a non-justiciable political question, and 3 felt that the court should nonetheless decide it. The implication of that is, the court being evenly divided, the judgment of the lower court is affirmed, and that's what happened. It was particularly painful for me because Judge Espinosa was a friend, and Judge Dorsey had questioned whether I should be reappointed and voted against it. But it was quite clear to me that the lower court had reached the correct result, and that the appointment of a judge that required not only nomination by the governor but confirmation by the Senate was inherently political in nature. And so I had to vote the way I did. And I was the senior member among the 3 justices who voted to affirm, and therefore I had to write the opinion, and did. I remember that there was an excellent constitutional scholar, Gerald Gunther, who later told me that he thought that the 3 of us who voted to abstain because it was a just non-justiciable question got it right, but he said the students in the class thought that the other side had the more appealing argument. So that was, as far as I was concerned, it was tragic, because I thought the state had lost a good judge. And I remember meeting Judge Murphy, her original, one time she'd been married to Michael Murphy, Judge Espinosa, and I just simply said to her that was a very hard opinion for me to write. And she very graciously said to me that she understood fully. And then an interesting footnote is, thereafter she was renominated by a different governor. I can't remember who it was. And at that time I was chairing the Judicial Appointments Committee for whoever was governor. I did it over several years and for several governors, but when her reappointment came up, I, with a light heart and total confidence, wrote an enthusiastic report that, yes, that she should be reappointed. And she served with distinction, most recently on the appellate division. She's written a letter announcing her intention to retire shortly. But for me, it was a drama laden with lots of personal considerations. But I have no doubt we did the right thing.
Well, that kind of leads me to another issue that we like to talk about in these interviews, the idea of your thoughts on the system overall. New Jersey is kind of, and you touched on this the other day when talking about Vanderbilt's reformation in 47, but, going to an appointed rather than elected group, a more concise group, administration. What are your thoughts? Because obviously politics do play a little bit of a role, particularly at reappointments and so on. What do you think about the I guess impartiality and effectiveness of the court system as it exists?
Of the appointment process or the system as a whole?
I guess both, yeah. Or whatever you'd like to comment.
Well, as a product of the existing system, I think it's okay.
Mm-hmm.
Someone once said a judge is a lawyer who knew a governor. So the process is inherently political.
Mm-hmm.
And we've been fortunate in New Jersey, certainly with the governor for whom I served, Brendan Byrne, to have governors who take the process seriously. I know Brendan Byrne took the appointment of judges and prosecutors, because he'd been both, very seriously, and we spent a lot of time on it. And as long as you have a governor who is committed to preserving the integrity and impartiality of the judicial system, I think the system is secure. And of course the Senate has an important role in confirming. I question the validity of senatorial courtesy. I think it has no role, or should have no role, on the reappointment of a judge. At that point, I think a sitting judge is entitled to have his or her performance considered by the entire Senate. And the necessary effect of senatorial courtesy is to prevent the entire Senate from considering the merits of the candidate. I would go further and rid the system of senatorial courtesy on initial appointments, but that's a matter for the Senate to decide. I think it's still true that there is a Senate rule that precludes the exercise of courtesy on a sitting judge up for reappointment. I may be wrong on that, but I think after Judge Espinosa's experience, I think the Senate adopted such a rule. Whether they still have it, I just don't know. And it's really that's a matter for them to decide. It's a political issue. It's for that branch of government to decide. I think our system has worked pretty well. It's inevitable there will be political considerations, but as long as you look for qualified candidates, but as long as governors look for that and the Senate looks for that, I think the system's okay.
Well, let's talk about the Sherman versus Citibank case, which came back to something that you had dealt with quite a bit earlier in your career, the banking industry.
Yes.
Tell us a little bit about that case.
Well, the underlying issue was whether the term interest in the relevant federal statute included late charges on credit cards. And it also involved the notion of preemption, that federal law preempts state law and or can preempt state law. In that case, there was a countervailing state statute, I believe, which said that the term interest did not include late charges. So somebody had failed to make a credit card payment. The credit card company imposed a late charge, and the litigants were off and running. And it was pretty clear to me that federal law did include late charges as interest, and that law preempted the state law that said no, late interest did not include late charges. And so to me it was very clear from the get-go. A majority felt the other way. I wrote an opinion. I don't know if anybody joined it. Justice Garibaldi may have joined it. Somebody else may have joined it. But that issue had arisen in another state as well. Both the New Jersey case and the other case went up to the U.S. Supreme Court. U.S. Supreme Court wrote an opinion saying, hey, look, this is federal law. Interest includes late charges, and the federal law is supreme. It preempts the state law, and that's what happened. I tried very hard to work out my differences with the author of a majority opinion, but had no luck on that instance.
And tell me, please, about the Kernan versus 1 Washington Park renewal case.
Yeah. That involved a lawyer's obligation of candor to the court. And my recollection is that it came out of a slip and fall case in Newark, and the issue arose whether the defendant property owner was liable, and the defense lawyer had failed to disclose a relevant fact to the court and to his adversary, so that the plaintiff, I think, had let a statute of limitations expire, and I simply wrote a concurrence in that case. The court agreed that to grant relief to the plaintiff, but I simply wrote a concurrence pointing out the importance of the lawyer's obligation not only to the client but to the court to be candid in the disclosure of facts.
Now, there were two cases that were quite a distance apart in terms of time, but you kind of linked them together. The Gennari versus Weichert case and the Ramirez versus Autosport
Yeah,
case.
they both involved consumers. Um, the Gennari case had very involved facts, and what we said, the bottom line of what we said was that realtors were subject to certain provisions in the Consumer Fraud Act. And Ramirez involved a couple who had gone down to an outfit that sold trailers. They agreed to buy a trailer. I thought they'd been treated pretty shabbily, and the trailer, when it was delivered, had some scratches and things were missing and so forth. And what the court did, and what we did in the opinion, was recognize a rule called the perfect tender rule. And that was a rule that had come up through the common law, had been incorporated in the Uniform Commercial Code, and said that when somebody agrees to buy something, the buyer is entitled to it in perfect condition if it's new. And a corollary has developed particularly in this age of mass production, that rule exists, but the buyer has to give the seller a chance to correct whatever the problems were. And so what I said in the opinion was, we're going to retain the perfect tender rule. You're entitled to something. You're entitled to a car that doesn't have a scratch. You're entitled to a TV set that doesn't have a knob missing. But the consumer should really give the seller a chance to correct the condition before calling off the deal. And I remember I put a line in the opinion that said something along the lines of what I just said, that in this era of mass production, we're accustomed to products with scratched surfaces, knobs missing. And one of the newspapers said, tragically, that's right, but we wish it weren't so.
And another case, State versus Warlock.
Yes.
If I'm pronouncing that correctly, Warlock.
Warlock.
Yeah.
Given the fact that the defendant was charged with the murder of two people, that's the name might ring a bell. But what that did, it provided the opportunity to look at the law of criminal insanity, because in that case, the defense was in criminal insanity. And like the felony murder rule, how the law views insanity as a defense in a criminal case has changed over time and from jurisdiction to jurisdiction. In New Jersey, we have what's called the McNaughton Rule, which goes back to the 19th century in England, which says that in order to satisfy the defense of criminal insanity, the defendant must not be able to know the nature and quality of his act and must not be able to distinguish right from wrong. Warlock was convicted under that test, and we affirmed the application of that test. It was quite clear to us that that's the test that the legislature wanted to apply. And I think that we try hard to follow the intent of the legislature, particularly in criminal matters. But it provided me with the opportunity to consider some of the alternative tests for criminal insanity. The Durham test, the impossibility, the irresistible impulse test, some other tests that academicians have provided. Also, a test that Chief Justice Weintraub put forth that he said criminal insanity really should not apply to the culpability determination, but to the sentencing determination. So I considered those different concepts, but ended up saying the legislature has clearly provided us with the McNaughton test. That's the test that applies in this case, and under that test, the jury correctly found this defendant liable for the 2 homicides.
Before we get to the end of your time on the Supreme Court, I wanted to go back to a case from earlier in your tenure, in the first few years, the Taquoia versus Crowe case.
Yes, that case, I think I can safely discuss a little bit of how that decision evolved. It came to us as in effect as a palimony case, but that's not what the case is cited for. I initially circulated the opinion, and then another member of the court wrote a separate opinion. I can't remember whether it was a concurrence or a dissent, but went into the issue of the propriety of an injunction in that case, which forced me to reconsider the majority opinion and address the issue of the tests you have to meet for the issuance of an injunction. And that's what I did. And that's what, if you were asked 99 lawyers out of 100 what Crowe against Taquoia stands for, if they were familiar with the case, they would say, oh, that's the case that gives you the test for the issuance of an injunction, and not the palimony case, not the palimony issue. It's just funny how it evolved. I mean, but that case, I think, still is followed for the issuance of injunctions.
Now, one of the last cases you wrote an opinion for was AVB versus Hill Warlock.
Yes.
Tell me a little bit about that case.
Well, that case involved the duty of a lawyer of a law firm to clients. The law firm had conflicting duties. Husband and wife had gone to see the law firm about wills, and the proposed provision in the wills said that under a certain set of circumstances, the children of each spouse could inherit from the other. Unbeknownst to the wife, the father had fostered the birth of a child through another woman. That woman came to the law firm, and the law firm erred in the spelling of the names of the initial, I think it was the husband and wife, so that nobody picked up that there was a conflict. And what we said was that the law firm could disclose to the wife the fact that her husband had fostered a child out of wedlock, but couldn't disclose the name of that child. It was a very sensitive case, and in this era, to me, it was understandable. I mean, in a big law firm like this, every day there are dozens of conflicts, emails that go around. And I can understand how somebody could misspell a name, particularly when a matter is coming in and it's a new matter. But that was what that case was about. I had another case that attracted more attention, Petrillo versus Bachenberg,
Mm-hmm.
and that involved an attorney's obligation to a non-client, and the attorney for the seller had knowledge of percolation tests, if my recollection is correct, delivered some of those tests, but not all, to the realtor with the intent that they be delivered to the buyer. And we said that there was an obligation that ran to the buyer from the attorney for the seller under these circumstances to disclose all of the tests, not just some of them. Mm-hmm. And that attracted attention because it involved the imposition of a duty on the lawyer to someone other than the lawyer's client.
Mm. Hmm. Well, are there any other cases that we haven't brought up that you'd like to discuss?
There's 250 of them.
Yeah, I know. Yeah, we can't.
I think we've covered enough.
Yes. Before we talk about your decision to retire, let's talk about some of your moot court activities and speaking engagements. One of the things I was interested in that you mentioned in our pre-interview was going to speak in Europe, particularly Yugoslavia. Can you tell us about that experience?
Well, as I mentioned when we were discussing right to choose against Byrne,
mm-hmm.
In that case I got into notions of federalism and what is the role of the states to the federal government, particularly what is the role of state courts to federal courts. And that became relevant at that time because I think generally speaking, one can say that the Berger Court and the Rehnquist Court took a more conservative view on issues such as the rights of criminal defendants, which gave rise to the question of should the state courts step in and render opinions more consistent with those of the Warren Court. So anyway, I had spoken and written a lot on federalism, and the USIA, United States Information Agency, asked me if I would go to Europe, to two countries that were having federalism issues, the former Yugoslavia, and the fact that I'm saying the former Yugoslavia gives you some indication how successful I was, and Spain, which was having problems with the Basques and in Barcelona and so forth. So I did. Penny and I went over, and I spoke in various provinces of the former Yugoslavia about what the relationship of that province might be under notions of federalism as applied in the United States. I think I must have been a complete failure because shortly after I left, they began shooting at each other. Then I went over to give a similar talk in Barcelona. That was the end of my European speaking engagement. And in Spain, there is a law, at least there was at that time, that imposed a tax on banks where they could either pay the tax or expend an equivalent sum to advance the arts. And whatever bank I spoke in had built an exquisitely beautiful stadium with a lovely booth with all kinds of controls. And the night that I talked, I think there had to be half a dozen translators up there. I think there were more people in that translation booth than there were in the audience. And as we learned subsequently, that was the night that Spain was playing Netherlands for the Europe Cup. And the Spaniards were more interested in seeing that for understandable reasons than they weren't hearing me talk about federalism. Mm. But it was a good trip, and I enjoyed it.
Mm. Well, I'm curious about your trip to Yugoslavia. The audiences you were speaking to, how receptive were they to the ideas you were putting across?
Hard to tell, because I was speaking in English, which required translation, which somewhat modifies whatever impact. But the audiences, I think they were generally law students, people from the legal community, all of whom were very well behaved. Mm-hmm. I think things went well, but who knows?
Now you have listed a number of speaking engagements. I don't. If there's others you want to talk about than the ones I'm going to bring up, please jump in.
You fire away.
I wanted to ask about the Brennan lecture at NYU.
Yeah, well, we talked about that a little earlier, and I think we've said enough about that.
All right. And then the Toledo Law School lecture, that was the Catcher in the Rye.
Right.
Yeah. Tell me a little bit about that.
What I did, it was on the 50th anniversary of the Catcher of the Rye, so I latched onto that and picked up a theme that both lawyers and judges should think about acting as catchers in the rye. You may recall the scene in The Catcher in the Rye where the hero is standing, visualizes himself standing on the edge of a cliff, and his kids play. Holden Caulfield, the protagonist, is standing there to prevent them from going over the cliff, and he becomes the catcher in the rye. And I said that lawyers and judges can have a similar obligation. It's easy to perceive one for lawyers, but I thought that our court had acted as a catcher in the rye in our school finance cases and in, the Mount Laurel cases as examples. And curiously, a couple of years later, I got a call from the dean of a law school out in California who said, "I just want to thank you for that." He said, "I'm using it as the basis of my commencement address today," which made me feel good.
You were also active in Moot Courts. You put down UVA and Seton Hall with Justice Kennedy and Justice Alito.
Yes.
What do you recall about those experiences?
Well, I mean, that was quite an honor. That was with Justice Kennedy while he was on the Supreme Court, and with Justice Alito while he was on the Third Circuit. But I enjoyed getting around, to different law schools: Michigan, Cornell, Rutgers, and so forth. It just like the Appellate Judges Conference, like the UVA LLM program, they were vehicles for getting out, meeting and talking with people about the law outside the context of the seven of us who comprised the Supreme Court for so many years together.
Mhm. Any anecdotes from those moot court experiences?
Oh boy. None that come to mind.
Okay.
None that come to mind.
All right. Now, in 1999, you decided to retire from the court, which was about 3 years before you would have been forced to by
Right.
mandatory retirement age of 70. What, can you
Why?
share why?
Yeah. I loved being on the court, and I was reluctant to leave it. But I'd spent over a quarter of a century in one form of public service or another. And although from the perspective of some people, the compensation might seem more than adequate, I hadn't been able to save very much, and I wanted to make sure that my wife was adequately provided for. And I thought I ought to get started. And that's what I did do. I came here to Riker Danzig, had a very active practice, doing all kinds of things. Special investigations for corporations, arbitrations, mediations, working with lawyers on appeals. And then tragically Penny became ill, and I felt that I should be with her. And in view of her death, I mean, I really need not have left when I did, but I'm glad that I did leave when I did, because it provided me the opportunity to be with her at a time when she needed me.
And just to bring us up to date on your family, you had 4 children, as you
Yes.
mentioned yesterday. How many grandchildren do you have?
I have 12 grandchildren and 3 great-grandchildren.
Right. And from what you've said, it sounds like some of them have followed in your footsteps, going into the law. And
Yes, let's see. My son is a lawyer here in New Jersey, Jeff. My son-in-law, Bob Gilson, is now on the appellate division. On the grandchildren, Shannon works with the public defender in Charlottesville, Virginia. Her brother, Stewart Ryan, is in the process of moving from San Francisco to Richmond, Virginia. My grandson, Stuart Gilson, is with a law firm in New York, and he's going to start a federal court clerkship. And my granddaughter, Laura, not only went to Hamilton, as did Jeff and Bob Gilson, but she just graduated from Stanford Law School, and as we sit here, she's home studying away for the bar exam next week. So, yeah, there are more members of my family who are lawyers than maybe the world needs, but there we are.
well, you talked in yesterday's interview quite a bit about the impact of your family, and also the scholarship that you got going to NYU on your views towards public service. Do you think you've actively passed that on to your family, or?
I hope so. Let's see. I think we'll have to wait and see.
Mm-hmm.
I know that my children are very much aware of the obligation to give back. Jennifer was on the governing body of her town in Pennsylvania and served as president of her school board. Wendy is a public school librarian and is on the board of the library in her town. No, I think the kids have been pretty good.
Well, looking back in your time on the court, what do you think of as your most significant work, or what you're most proud of?
I guess I would have to say that I think I took the work seriously and gave the best I had and tried to be the best justice that I could be. Whether I succeeded or not is for somebody else to say, but I know that was my undertaking, what I tried to do.
All right. Well, is there anything that we've skipped over? Any stories you want to share? That
We've probably gone on longer than any viewer wants to see.
No, I think people will enjoy hearing your recollections. But thank you so much for all your time today. I appreciate it, and your time yesterday. And
Thank you,
I
Sean.
think it'll be a very valuable interview.
Well, I hope so.
Thank you, sir.